begin at the beginning, when our constitution first came into force, it had to grapple with social inequalities of a different order altogether. We had in our society persons who were called depressed classes by the British, who were untouchables, who were actually outside the Varna system, and who were treated as serfs instead of as human beings. And our constitution, therefore, had to do something to remedy this terrible social disorder. It chose a particular method which I don't think was chosen by any other written constitution till that date. Certainly not by the US Constitution, which also had centuries of slavery and servitude. So that ultimately our constitution first chose the fact that there should be empowerment in the legislature. Now, in order to empower what was called scheduled castes and scheduled tribes, euphemistically, the President of India was to make a list of these depressed classes under Article 341 of the Constitution of India. And this list could then be amended, either added to, modified, detracted from, only by Parliament. The same went with the scheduled tribes under Article 342, because we also had a large number of tribals all over this country who perhaps were its very, very original inhabitants, who also were in great need of social upliftment and being brought into mainstream life and society. Now, once these lists were made, there were constituencies reserved for scheduled castes and scheduled tribes, both parliamentary and in the Vidhan Sabha of the states. And they were to follow the proportion that these persons had to the total population of the country. So that in Parliament and in the Vidhan Sabhas, by Articles 340 and 342, what was reserved for them was roughly 15% of the seats, of the total number of seats, and 7.5% of the total number of seats in the case of the scheduled tribes. The focus at the start of the Constitution was on, therefore, these scheduled castes and scheduled tribes.
Honorable Mr. Justice Rohinton Nariman, in his address at the 10th Justice V.R. Krishna Iyer Memorial Law Lecture, delivered a comprehensive discourse on the topic, Economic Criterion and Subclassification of Scheduled Castes, as Reservation Eclipsed Merit Altogether. Justice Nariman traced the constitutional framework supporting reservations, citing pivotal provisions such as the Articles of the Constitution of India, 15.4, 16.4, 46 and 340, and referencing landmark judgments including the Indra Sawhney case, which have shaped their judicial interpretation and led to constitutional amendments. He critically examined the tension between meritocracy and social justice within the context of the reservation system. Furthermore, Justice Nariman analyzed the evolving judicial stance on subclassification of scheduled castes and the inclusion of economic criteria, stressing the need for these measures to be meticulously structured to ensure they serve the broader constitutional objective of achieving substantive equality.